The idea of the law is that it cannot be easy for the state to take life. I don't think there has been an inordinate delay in these hangings. We are now looking at just over 7 years since the incident, and we've had to go through the trial court proceedings, the High Court confirmation, the Supreme Court hearing of the criminal appeal, the review petition in that, the mercy petitions and the challenge to the rejection of the mercy petitions, all procedures laid out in the law. And to complete all these procedures in little over 7 years, I certainly don't think there has been an inordinate delay in this case. The charge that the accused have indulged in delaying tactics is a disingenuous one, to be honest. They have only exercised options available to them in the law, and it is fair that the law provides them these options. The idea of the law is that it cannot be easy for the state to take life. And that cannot be the idea of our procedural system either. It is that the state must be very sure, it must follow the law, it must follow all the procedures set out in the law, and the idea is to make it as difficult for the state to take life, because we should not be giving that power to the state that easily. The most obvious one, I would think, is the societal bloodlust in both these cases. Just the amount of noise that was created just made it seem so inevitable that these executions would be carried out from day one, and therefore these executions don't really come as a surprise, really. I think the most second one and the more worrying one is the nature of how courts adjudicate these cases towards the end. I think there's a certain performative element to hearing these cases, but when you really analyze how courts engage with the arguments being presented in these cases, there's much that is left to be desired, really. The broader concern is that in cases like this, the well-documented error that sentencing courts and sentencing judges seem to indulge in has continued. And that error is specifically that the law requires you to consider both mitigating information about the accused and aggravating factors. And unfortunately, in many of these death penalty cases, we see a very crime-centric approach to sentencing. Now, the general public might feel that's absolutely fine, but unfortunately, that's not the law. That's not what the law requires. And we, time and time again, we see sentencing courts and sentencing judges leaning heavily on aggravating factors concerning the crime to confirm the death sentence, while giving very little importance to mitigating information or demanding that mitigating information of a certain quality be presented before court so that a proper job can be done of sentencing.